Why attorneys at law legally nullify your rights. Understanding, representation, and legal infancy. What if hiring an attorney actually stripped you of your rights instead of protecting them? It's not a conspiracy, it's legal definition. Let's break down why being represented means you're legally considered incompetent and how to reclaim your standing. When a person retains an attorney at law and becomes a client, they enter a legally defined relationship rooted in assumptions of legal incompetence or minority. Under corpus juris secundum, the term client is associated with an infant or person of unsound mind. While seemingly archaic, this classification has powerful implications. It renders the client a ward of the court, incapable of speaking, acting, or asserting rights on their own behalf. This is not just theoretical. Once an attorney is hired to represent you, you are no longer presenting yourself. The attorney represents you. In legal terms, this distinction is substantial. A self-represented individual retains full standing under common law and constitutional rights. A represented individual waives all such rights and becomes a passive party to the proceedings. This is because an attorney at law is an officer of the court, and the court's jurisdiction depends largely on the voluntary submission of the parties involved. Once you sign a retainer or authorize the attorney to speak for you, you consent to their exclusive control over legal filings, strategy, and interpretation of the facts. You will become subordinate to that of the court and the procedural rules of the Bar Association. Contrast this with the role of an attorney in fact, defined in Black's Law Dictionary as a private agent empowered by a power of attorney, POA. An attorney in fact operates strictly under the terms of a contract, does not assume or alter your legal status, cannot waive your constitutional rights, and remains subject to fiduciary duties enforceable by law. In this relationship, you retain control. You may grant limited authority to perform specified acts, such as filing documents, negotiating terms, or initiating legal processes, but you do not surrender your identity or standing. The distinction matters because courts routinely presume incompetence in represented individuals. They apply doctrines such as in loco parentis, in the place of a parent, or parens patriae, parent of the nation, to justify overriding your interests for your own good. But if you appear as a competent man or woman in propria persona, rather than pro esse, a statutory term, those presumptions dissolve. Understanding this distinction changes litigation strategy. It enables you to appear as the beneficiary of your own legal standing, appoint a private fiduciary, attorney in fact, instead of ceding control to an officer of the court, and reclaim the jurisdiction of the court as one of contract and equity, not statutory compliance. This is why attorneys are so often adversarial when confronted with contract-based legal actions. They are trained to operate within statutory procedure, not contractual remedy. When confronted with a party asserting full capacity under contract and common law, they resort to intimidation, sanctions, or motion practice because they lack the tools or training to combat properly presented private claims. Footnote: this section clarifies the legal effects of retaining an attorney at law, how doing so converts a competent party into a ward of the court, and why acting under power of attorney preserves one's full legal capacity.